Hi, everybody. Thank you for joining Wealth Protector TV. This is Paul Hitchcock with Barth. We're an asset protection, estate planning, and business planning firm. Really excited to have my two guests here today. Dave Singh, an expert in estate planning. Harry Barth, an expert in asset protection. And we want to jump in and give you an overview of what these two disciplines are all about and to make you a little bit smarter today. And we're going to start with Dave. Dave, we want to jump in with you for an overview of estate planning. Let's get right into it.
Absolutely. Thanks for having me, Paul.
Yeah.
And when we think about estate planning, one of the things that we encounter with our clients is that they don't feel that they have a need for estate planning. What is an estate? I don't have an estate. Why do I need to do this type of work? So what are we really talking about when it comes to estate planning? What we're really thinking about is, do I own a home? Do I have children? Do I have other assets? And these are everyday families that we're working with that just want to make sure that their things go to the people that they intend when they're no longer around. And ideally, can we avoid court? Can we eliminate family conflict, minimize it, if we can't eliminate it? Those are some of the things that our clients are thinking about. And so it's not really the case that we are doing estate planning and we are only working with, for example, high net worth individuals or folks with really, really complicated situations. It's actually everyday families. And so how do we accomplish estate planning for everyday families? Essentially what we're doing is a suite of different legal components that we're putting together. And that suite is centered around a trust vehicle. And our clients may have heard revocable trust, living trust, those terms. That's really the center, and we think of that as a vehicle that we're building for our clients. And so around that trust vehicle, we will build out several other components. And so we will have, for example, pour over wills, which is a specific component that supports the trust. We'll have powers of attorney for financial and for medical decisions. And I'll go into each of these in a bit more detail. But essentially, just as an overview, this is what we're looking at. And these are some of the components. We'll have a healthcare directive, which is that power of attorney for medical decisions. And ultimately, we'll have, final disposition instructions. What do I want to happen with my body, with my remains when I'm no longer around? And so these components are designed to work together and integrate in a way that covers many, many different scenarios. And hopefully there are no gaps. As long as we've done our job as planners, which we will, there are no gaps in the planning. We've covered scenarios to the extent that we can. And that's really the objective here. And nothing that I've just said has to do with the amount of assets that we have or the size of the estate.
Right, yeah, because I was going to say, what I hear you saying is estate planning is not, you don't have to be a multi-millionaire or billionaire to need estate planning. Bill Gates or Warren Buffett, almost everybody has some level of an estate.
That's correct. That's correct. Yeah.
Yeah.
So when we're meeting with clients, some of the initial conversations that we'll have, sure, we're going to ask about assets, but we're really asking about, assets, family, but also what is important to our clients. So what are the things that are really important to you? And that could be a variety of things. It could be, it could be heirlooms from previous generations, but it could be instilling the next generation with a certain set of values. And how do we incorporate that into this vehicle that we're creating, which is the living trust, the revocable living trust? How do we build that into that vehicle? How do we design that roadmap for that vehicle so that it reflects that?
Is it safe to say, Dave, that there's as much of an art as a science that goes into building a proper estate plan, with talking to somebody like you who's fleshing out these sort of discussion points that really matter?
I think that would be a fair assessment, and where that comes from, particularly, Harry having been practicing for decades and decades, myself being, I do handle litigation as well. when you've been exposed to the other side, when you can see when things go wrong, or just in my personal experience, for example, my family, we lost both of our parents by the time I was 17 at different ages. But by the time I was 17 years old, both of them had passed on. So there was some estate planning in place. My father did have a will, but he didn't have a trust, and we had a house. And so we found ourselves in probate court. And we found ourselves there for 5 years. You know, our attorney didn't do a great job, unfortunately. And so when you've seen that other side, and certainly with with clients that I've represented since then, and seeing situations where the planning was not sufficient, and we're attempting now to settle the estate, etc., or things go sideways, and when we have conflict among the families and there's litigation, you can really, having had exposure to that other side, you can really think about that. It's a huge benefit on the planning side, because you can draft the documents, and you want to draft the documents in a certain way so that they are, we are addressing some of these risks. When we're meeting with clients, often it's not that we're asking the questions that they have answers to, it's asking questions that they haven't even asked themselves yet.
Oh, right.
That's really that's our value in those settings. So
yeah, and I heard you say that your parents had a will, but still went to probate. So a will doesn't allow you to avoid probate. It's living trust that really does that.
That's right. So essentially, there are two pathways to probate court, right? So one is if there's real estate involved, and this is in California, there's real estate involved, or if there are other assets in excess of roughly 150,000. And often we have both. So we have real estate and we have other assets. Now, if those assets or that real estate is held in a trust, there's not a need for us to go to Big Brother, which is a probate court, and have the estate supervised as we settle it. We don't need to be subject to that probate court process. But if those assets are not held in the trust, and there are, like many things in this area, there are a lot of different exceptions, and I won't go into them now, but just at a very high level, inside a trust, done correctly, should not trigger a probate. Outside of a trust will very likely result in a probate if we have real estate or 150,000 in other assets. And so that was the case with my parents. We did have a family home, and there were some other assets, but not enough to trigger a probate. And so, right. But we did have the family home, and so that was why we had to go through the probate process. And like I said, it ended up being a really nightmarish process for us. Yeah. Well,
some of the components of estate planning, you mentioned advanced medical directives, financial power of attorney. Could you just comment briefly on why those are important?
Absolutely. So that's another, common, I think, understanding that clients have coming into the process is that, okay, well, I don't have an estate. I don't have what you would think of as an estate, but I do recognize that I still need to do this to avoid probate. But actually, and Harry and I were just talking about this before we started, is that the other components potentially are just as important, if not more important, which is I'm still around, but I have now become incapacitated. So I'm no longer able to make those decisions for myself. How do we plan for those scenarios? How do we make sure that the right person is making the right decisions at the right time? And so that's where we would have, that's where an advanced healthcare directive, which is, we think of that as a medical power of attorney.
Right.
A power of attorney document, just to start there, is a document that appoints someone else to make decisions on behalf of who we call the principal, the person creating the document. And so that can be used for financial. There's a specific document for that. Or we would have an advanced healthcare directive in California is what we use for medical decisions. And essentially that's to cover that period where we may still be around, but we're just not able to make decisions, or we're not able to communicate our decisions. And so we're regarded as incapacitated in that scenario. And so now we have somebody who's coming in and can do that.
Okay. And Dave, when you do the living trust, are you sitting down with the family? I mean, how do you give advice about that? Who's in that meeting, and how do you initiate that?
Absolutely. And so it's really similar to when we meet with a client after they've lost someone. What I explain to clients is that every loss is difficult, but every loss is also unique. So we share the fact that we've experienced loss, but we also have to recognize that their loss is unique from anyone else's experience. Very similarly, when we're meeting with estate planning clients, so we have the opportunity to do some planning. Everyone's still around. Everyone still has capacity. Ideally, that's not always the case. What we explain is that every family is unique, and
Right.
for your family, it may be beneficial to bring, typically adult children. So it may be beneficial to bring adult children into the room, into the conversation. All of this is done with the client's permission, of course. But if everyone's on the same page there, that can be hugely beneficial because we've now created continuity between the work that we're doing and the next generation. And when we meet in the future, hopefully distant future, we're not strangers to those children.
Right.
They were with us when we created those documents, and they were with us through the process. They actually maybe heard their parents talk about why they are making certain decisions. And people will generally, families will generally, have integrity around that and not challenge things if they've heard it from their parents' own mouths. And so that's ideal. That's an ideal circumstance, is that we would have the full family involved. But many times, and it's not because there's any conflict or anything negative going on, but many times parents just want to keep these decisions to themselves, or they don't want to put that stress on, or that thought onto their children. They don't want them thinking about them not being around. And so they will keep their planning to themselves, and that's completely fine as well. That's kind of the starting point. We will only deviate from that if they say they want their children involved. Otherwise, we are working with the parents or the individual, the couple or the individual directly. We're not involving other folks.
Okay. Well, Harry, I know that estate planning and asset protection are two different disciplines, but often integrated. Let's jump into asset protection and
Sure.
talk about that. Yeah.
Sure, I appreciate that. And, as I was sitting here listening to Dave, this is so critical for everybody. He brought it out, the impact on a family's culture, a family's traditions. As I like to describe it, this is more than a set of clinical legal documents. This is a movie script. This is the cast of characters. This is so important, so critical. Dave, thanks for that explanation. It was really, really wonderful. I appreciate it. Asset protection is, in many ways, living estate planning. Dave is working really hard to keep creditors out. Dave's working really hard to keep you out of court situations. Dave's really hard and working really hard to set up a strategic program. And what we have seen many times is someone like Dave will, just put together a masterful estate plan for the transition of assets from generation one to generation two. And then what happens is there's a legal crisis, a lawsuit, or another unfortunate economic catastrophe that has hit the family. And now guess what? There's no money to keep inside that estate plan to transition to the next generation. So what we're going to talk about here is, what is asset protection planning? And it's to make sure that Dave's estate planning can work because it's filled with the assets that are moving from one generation to the next. Asset protection is nothing more than organizing our assets, Paul and Dave, in such a way that it can withstand the onslaught and have a better result in a unfortunate litigation that we would have in the absence of getting it done. And all of these planning, estate planning, tax planning, financial planning, are all subsets of asset protection planning. We're protecting assets, the family's assets. When Dave talked about his family and going to probate for 5 years, the cost that's involved, the time that's involved, we're losing assets, we're losing money in doing that. It's a loss of asset protection. But there are some things that we need to know about asset protection planning. And we'll start with some interesting statistics. Statistics are that a lot of people don't recognize that we won't use 2020, or the numbers are not yet in for 2021. We'll use 2019. because that was the year before the pandemic, on how many actual lawsuits were filed in the United States of America. When I go around the country speaking about this, people say, oh, 1,000,000, 500,000. It's 50 million. 50 million lawsuits are filed every single year plus in the United States of America. Now, of course, that includes divorces and criminal actions and tax actions and immigration actions and tort actions and contract actions. Anytime we ask the judicial system to do something, it begins with a complaint and a lawsuit. 50 million. And another interesting component is to recognize that 95% of all litigation in the world occurs in the United States of America. Only 5% occurs outside the United States of America. There's some good reasons for that. So one of them is our system. In our system and in many other systems, you bring a frivolous lawsuit, you lose, you pay the attorney's fees for bringing that. In the United States of America, we pay our own legal fees absent a contractual provision. So there's no brakes on somebody bringing an action because they settle for $200,000 because that's the cost to defend. It's just terrible. We also have contingency fees, which are illegal in many other countries. That started off as a real good system, Paul and Dave. It was designed to allow the legal system, which is an expensive system, to be available to people that didn't have means. So it allowed them to partner with lawyers to make sure that their rights are upheld. Well, it's turned into a multi-billion dollar mass tort class action business that is absolutely ridiculous. And then the other thing too is punitive damages. This is just an add-on to lawsuits. So between punitive damage, contingency fee lawyers, and pay your own legal fees, it's a very lucrative place to bring lawsuits in the United States of America. Now, there are some axioms of asset protection planning that I think are critical and very, very important. The first axiom that's very, very important, and I think we all understand this very well, is you don't engage in asset protection planning after the event occurs. So if Dave's driving down the road, God forbid, on the freeway and hits a motorcyclist, that motorcyclist not coming up, who happens to be a thoracic surgeon masquerading as a Harley Davidson guy on the weekend, now is not the time to begin asset protection planning. But yet, after 50 years of this is when everybody calls. Oh my God, I could lose everything that I have. Now it's time to call the lawyer. Asset protection must be proactive and preemptive when there are no clouds in order for it to be effective. So asset protection planning begins long before the event occurs for it to be effective. That's a very, very important axiom. I think the most important axiom of asset protection planning.
But Harry, it's not when the lawsuit's filed, it's when the
it's when the event occurs that would give rise to the lawsuit. So when Dave hit that motorcyclist, that was the moment that it occurred, not when he sued 18 months later for damages as a result of that. And a second very important axiom of asset protection planning, which really falls right into Dave's court in our meeting today, is that a lot of people feel, and Dave will bear me out on this, that their living revocable trust that was put together for privacy, probate avoidance, the script for the family, for the tradition and culture, protects their assets from the claims of third-party creditors. And you can dispel that immediately. It provides zero asset protection planning. Now, Dave can provide asset protection planning for the next generation on how the assets move from generation one to generation two. Generation two, so trust that's established by the parents can provide good asset protection planning for the children. But for ourselves, when my wife and myself, Dave and his family, and Paul and your family set up our living revocable trust and put our assets inside, that provides no asset protection. And I get an interesting, sometimes quizzical look from people, and they say, well, if it doesn't provide any asset protection, why did I do a living revocable trust? It said my house is in my trust, it's protected, right? The answer is no. The third very important axiom, and I think a critical one, is the over-reliance on insurance. So people come to our office and they buy umbrella liability insurance policies, and they have, let's say, a $2 million umbrella, and they proudly say, oh, we don't have to worry about asset protection planning. we have a $2 million umbrella policy. So I think it's really important to understand that insurance is a very important component of asset protection planning. We all should have appropriately and properly designed insurance plans. But what is that person saying to me and to Dave when they come in? What they're saying is that we don't think we are going to have a lawsuit or a liability that's in excess of $2 million, $3 million, $5 million. And there is no relationship between the amount of insurance that they have and the judgment that could come as a result of an action that they've caused. A lot of people seem to believe that the personal injury or predatory tort lawyer is only going to accept the insurance and be done. It's just not the case. If I have a $4 million judgment with $2 million worth of umbrella coverage, $2 million might be paid by the insurance company, and now they're coming after you for the other $2 million. Asset protection is to make that extremely difficult. Asset protection is not about the elimination of liability. Asset protection is to create doubt about collectability and lead to a quicker, mediated and or arbitrated settlement.
And Harry,
That's
I've
what
heard you say many times, it's not about hiding assets or anything.
No,
like that.
not about hiding assets, not about secreting assets. It's all about organizing assets in such a way so we're the best able to ward off an attack. And the way the analogy that I like to use, and I want to get back to insurance for a moment, is we have assets. We have worked very, very hard to build assets, our companies, our savings accounts, our retirement plans, our homes. And to me, it's smart to have a wall around them. It's just smart. And there are some walls that we build that are 3 feet tall, and some walls that are 5 foot tall, and some walls that are 10 foot tall. But we should have walls. Asset protection is building walls to make it more difficult for people to reach that which we've worked so hard for, so we can enter into a quicker negotiated mediated settlement. But one thing I wanted to say before I leave the insurance component for a second is another, we'll call it misnomer, that we find within our client base. And that is when people have a quote unquote an umbrella policy, they feel that almost everything that can happen to them under the sun is covered by that umbrella. And I don't blame them, because the way it's promoted, umbrella coverage, it's not umbrellas with holes in it, it's umbrella coverage. They feel that all of the liabilities that they can have are covered there. And yet I tell them, it's a little bit of dry reading. Read the 65 pages of the document for all the covenants, conditions, and exclusions that are within those policies. So if it fits within the specific coverage limitations, they're good. If it's outside, like punitive, special, exemplary damages, we had an example, Paul. We had a case up in the Bay Area where we had a landlord and they had a mold problem, and the tenant said, "Oh my God, I'm getting sick from the mold," and so they sued the landlord. And then the landlord tendered it to the carrier and found out at that point that the landlord-tenant policy had an exclusion for mold. There was no coverage for mold. And although it was settled for $250,000 for the mold, it was another $350,000 of attorney's fees that had to be paid. It's almost $600,000 not covered because of the mold coverage and mold coverage exclusions. And there are tons of exclusions. So one of the things you have to do is look at the exclusions, look what's missing, and make sure we have appropriate and proper legal remedies for asset protection. And asset protection, guys and girls, not new. It's been around for a while. It's been around for the Middle Ages. It's real simple. If Dave worked all his life and amassed a fortune, he just wouldn't leave it in the center of the town, because the barbarians would come out and the robbers and steal all his stuff that he worked so hard for. So they built a castle. You could see them. You go there, visit the castles, big, thick walls. So they put that which was important to them behind the walls. But if walls weren't enough, so they dug a moat. And allegedly in the moat, there were alligators and crocodiles and all kinds of bad things along the way, and archers and turrets where they could turn around and shoot arrows. So the hope is that the more layers that we have, the formidable layers, the less likely that the robber barons were going to try to reach the treasure. Asset protection today is literally the same thing as that. Let's build some walls that make sense, that fall within. We don't want to kill a fly with an anvil, but make sure we have appropriate walls that are associated with it. And what I'd like to do in the time that we have left is talk a little bit about some of the things that we should look at as far as assets are concerned in the state of California. And one of the things that has changed in the last year, literally in the last year, is the homestead protection for our homes. So what a homestead protection is the amount of equity in our home that we can keep in the event that we have a liability against us and the creditor is seeking to take our home away from us in order to satisfy that claim. And I go around when I speak and I ask people in California, these are pretty top executives saying, hey, do you think you'll keep your home in the event of a large legal liability? And 60% say yes. Don't we have a homestead exemption in California? Yes, we do, but it's not complete. So let's talk about what it was and what it is now. Up until January 2021, if someone was single and owned a home in California, only $75,000 of equity, believe it or not, was exempt from the claims of creditors.
Nothing.
And if you're under age 65, there's $100,000 of equity. And if you're over age 75 or 65 and had a disabled person living in the house, they gave you $175,000 worth of equity that was exempt from the claims of creditors. That all changed on January 1st, 2021, where California became a little bit more aggressive with the homestead exemptions for people in the state. So let's share it with everybody today. So today, the California homestead exemption is a minimum of $300,000 and a maximum of $600,000 adjusted for inflation on January 1st of every year. The difference is the amount of the homestead exemption is equal to the median sale price of a home in the county where we live, with a maximum of $600,000. So for those people living in Los Angeles and Orange counties, it's right now it's around $650,000 homestead exemption. Riverside, San Bernardino counties, $480,000, $500,000 worth of homestead exemption. So that basically says is that if we have more equity in our home than that, our home can actually be sold. We get a check for the exemption amount. So we have great opportunities and things that we can do to protect homes from the claims of creditors. Another thing that we begin to see a lot, or in the short time that we have, is retirement plans. I want to talk about retirement plans because a lot of people, you got a house in a retirement plan, seems to be some of like Dave said, doesn't have to be in a state of $50 million to need estate planning. It doesn't need to be a state of $50 million to have appropriate and proper asset protection planning. I think that's the takeaway from today's webinar, that this type of planning is pretty much there for everybody. So when we look at retirement plans, we have to take a look at what is the exemption. So if we have an ERISA qualified retirement plan, 401k, defined benefit plan, money purchase pension plan, profit sharing plan, where there are more than two people participating in the plan, by federal law, that plan is exempt from the claims of creditors. However, IRAs, SEP IRAs, Roth IRAs are not ERISA qualified pension plans. In California, if the money was rolled into an IRA, a rollover IRA from an ERISA qualified plan, it keeps its ERISA exemptions. But sadly, those other ones are not. And so what happens there is that in most states, the amount of assets that are inside in a non-bankruptcy situation, IRA plans are treated just like retirement, ERISA qualified plans, and they're exempt from the claims of creditors. In California, we all need to know that all of those non-ERISA plans are subject to a reasonable and necessary test, where a court makes a determination based upon a subsistence value of how much of that retirement plan is needed by the family. And anything that's above that in the court's determination will be given to a creditor. Now, of course, that's a double whammy, as Dave just figuring out in his brain real quick. Two, one, you got to pay the income tax on that, even though it's going to the creditor, and if you're under 59 and a half, you have to pay the penalty as well. So can you imagine a couple $100,000 from your IRA non-bankruptcy going to a creditor? You have to pay the tax on the $200,000 and a $20,000 penalty. Wow, that's just
Yeah.
So I think that's important
Harsh.
to understand. But there's another point that's significant to know, and that is we're talking about whether or not a creditor can reach a retirement plan. But the other side is what happens when we want to take money out of a retirement plan. All right, so that becomes the other side, and that's not federal law, that's state law. So there are three versions of that I'd like to share with everybody. One, the law in the state says, hey, look, it was protected while it was in the retirement plan, Dave, but when you take it out of the retirement plan and give it to you, now it's you, and I have a judgment against you. It's gone. So once it's out of the protected environment, so you can't use it if I have a judgment against you, because if you take it out, I'm going to take it away from you. The second set of state laws turn around and say that what this really is deferred wages. So when you take it out, it's deferred wages. So therefore, we will apply the state's wage garnishment laws against the retirement plan, which means that we'll be able to take, in most cases, 25%. So if you took $10,000 out of the retirement plan, trace it back to retirement plan, $2,500 go to the creditor, $7,500 stays with us. And there are some states that say that if the tree is an exempt asset, then the fruit of the tree remains an exempt asset. California, believe it or not, is one of those states. So if we have $500,000 in our retirement plan, ERISA qualified retirement plan, and we need to take out $100,000, other than the income tax, state, and federal liability, if we can trace the source of that money back to that retirement plan that we used to buy a boat, the boat becomes an exempt asset as well. So that's a little bit of planning that I think everybody needs to know that it is a great idea. And last but not least, in the time that we have today, I want to talk about, and there are like 20 or 30 different items for discussion in asset protection, and a lot of advanced concepts with asset protection trusts, both onshore, offshore, and other alternatives in the use of spousal lifetime access trust. I'll talk just a little bit for a second about people and businesses that hold corporations and corporate stock. So when I travel and I speak and I talk to people that own a business, and that business, for example, is a corporation, and I'd say that they have a liability that comes because they crashed the car. So Dave, you crashed that car again on the freeway, and they're coming to Dave to collect. When they look down, I asked them, well, you have a business there. Do you think that they can take the assets of your business? And most people will say, no, I have a corporation. That's why I formed a corporation. No, they can't take that away from me. And I think it's really important to understand that there are two forms of liability that we all need to consider. One is a liability that's rising up from the inside of our entity, and another one that's rising up to the owner of the entity. For those assets that are rising up from the operations of our business, the corporation is effective at limiting liability so we don't lose our house, our bank accounts, our real estate because of a liability within the corporation, assuming it's run properly. But what a lot of people don't realize is when the liability comes to the owner, and the owner owns stock, I don't care if it's Apple stock, Microsoft stock, General Motors stock, or David Inc. stock, the creditor can take the stock. And when the creditor takes the shares of stock, if the creditor gets over 51% interest, they can control the company. They can liquidate the company. They get its receivables, sell its machinery, sell its intellectual property. A lot of business owners do not realize that. So there are tools and techniques that we can utilize to prevent that from ever happening. There's no reason to run a business where we can lose the control, managerial control of our business every day, or we can structure that business through what is known as a plan of reorganization, all right, into an appropriate LLC, taxed as a corporation, and one will never lose control of the business. So what's the story or what's the takeaway for asset protection planning? Just as when you meet with Dave or need to meet with Dave to plan our exit, or planning our exit, whether our exit's being planned as a result of death or planning because of mental infirmity, it's really important to have a game plan that's well organized. The best organization is what you're seeing at the webinar today. The coordination between David and Harry. David planning the exit, Harry making sure that we have the appropriate assets for the exit, and the coordination between the two is the best judicious use of your time and your legal dollars. And so therefore, what we all should do is do an analysis of assets and liabilities and what we have and what we don't have. And David and Harry should look at it. David commenting on and building for you the appropriate estate plan, and Harry and team building the appropriate asset protection plan. We coordinate the two together and we win the game. So what's really important for everybody, I want everyone to understand, is that David and I are offering to all of the viewers on this webinar today a free complimentary consultation with us to learn a little bit more about the things we spoke about. This was just a high-level introduction and how we can help you. And we appreciate all of you being with us on Wealth Protector TV today. And Paul,
Yep.
why don't you just close it up and thank you for bringing Dave and I on today.
Yeah, David, awesome. Harry, thanks so much. And for all those of you watching around this video, wherever you're watching this, because we stream this on Facebook, YouTube, LinkedIn, everywhere, there will be a way to contact us for your complimentary assessment. So look for that. Be happy to speak with you, and we'll see you next time.
Thanks. Bye-bye.
Singing